Ms Wilson.
Could I pick it up at Lord Russell in Benedetto, which is paid... Well, his judgment starts at 592. And what we see on reading the judgment is a reiteration of the fact that this is a case concerning the proper meaning, the statutory interpretation of the statutory words, and it is therefore a case of general application, can't be distinguished. And then there's albeit in his own words, that there's a similar approach to Lord Wilberforce in terms of not accepting that you can carve out a special rule for interest costs, because that's not fair to the other taxpayers who choose not to raise finance that way. But then, could I pick it up at 593 at G? Because we do rely on this in our written case as a way of expressing the test. And what Lord Russell says is, in my view, the question to be asked is, what is the effect of particular capital expenditure? Sorry,
you're reading at 593 at letter
G.
G, thank you. Got it, thanks.
What is the effect of particular capital expenditure? So this is like asking, well, what's the immediate object of this expenditure in the transaction? What's the effect? Is it the provision of finance to the taxpayer, obviously the facts of this case, or is it the provision of plant to the taxpayer, as the taxpayer there was arguing? In my opinion, the effect of the expenditure was the provision of finance and not the provision of plant. I would add that I do not seek to confine qualifying capital expenditure to the price paid to the supplier of the plant. I should have thought, for example, that the cost of transport from the supplier to the place of user, if the cost of transport is to the place of user is directly borne by the taxpayer, it would be expenditure on the provision of plant for the purposes of the trade. And there may well be other examples of expenditure additional to the price paid to the supplier, which would qualify on similar grounds. Now, we rely on that as saying, well, again, you're back to, you begin with your purchase price or acquisition cost, and that's all consistent with the policy of a wear and tear relief or a proxy for depreciation. And then you move incrementally out, but without changing the test. You keep the test the same, the statutory words don't change, and you certainly don't write in, because actually you'd really like a deduction in relation to your studies and assessments in environmental, that you write in the words, oh, and then with hindsight, can it be seen to have informed the provision of? I say you don't do that.
So apart from transport and installation,
well, they're mainly.
Are there other examples?
They would, I think, primarily be it. Not quite sure what but it would have to qualify on similar grounds. And it might be, of course, if you break down installation, you could have scaffolding, you could have all sorts of things. And you might not call it installation, it might be assembly. So you might buy part of the plant from here and part here, and someone has to assemble them, so it's not really installation. But it's all in that footprint of the same footprint. But I say it's certainly not extending the relief in the expansive way that we end up with the Court of Appeals test. And Ms. Parry, who I hope to hand over to very shortly, she will explain, and I think it will help on the facts of our case, how we say that fits with the actual evidence and where we would say you draw the line, and why there's a conceptual difference between, say, the expenditure on the studies and the assessments, and then the expenditure on the provision itself of the plan. But we say this is our way of expressing the test, the statutory test.
Can I ask you about one of the cases concerned the cost of advice as to which films to buy? I think it was Samarkand.
Move on to that now. So there are three other cases that I need to touch on. Two of them, I rely, in fact, on what the Court of Appeals say. So the SSE, which is a case about the meaning of the statutory word installed, I adopt paragraph 75 of the Court of Appeal judgment. It's not relevant, and actually it's completely consistent with HMRC's case, but it doesn't really help. And then McVeigh, I adopt paragraph 74 of the Court of Appeal's judgment. And as regards McVeigh, no court to date has found it of any assistance. And
what was the paragraph in the Court of Appeal?
74. And I'll hear what I'll reply if my learned friend makes his points, but I say it's fundamentally different because they were dealing with what was obviously a tool of the trade. They were just constrained not to find it was a tool of the trade by a system judgment, which was later overturned by the Court of Appeal. So then the third... Sorry, did I say 6? I've given you the wrong references. So McVeigh is 64, sorry, and...
you mean that paragraph 64 of the Court of Appeal's judgment?
Yes, I gave you the wrong paragraph numbers.
And
the other one is wrong too. I think it's probably 64 and 65. I've got so sorry.
no.
So 65 is SSC and 64 is McVeigh. I'm so sorry. Thank you. Thank you, Mr. Chairman. So then Samarkand, the first tier. So this is a first tier tribunal judgment, and it's addressed by the Court of Appeal at paragraph 66. And I think they may find it of some minor relevance. The context is all. So the big context is that this was an incredibly artificial tax avoidance scheme, which, with the ceilings on circular borrowing, sought to step up the amount of capital allowances that you could claim.
This is Samarkand you're talking about?
Samarkand, yes. And the actual relief was a relief for the acquisition of rights in relation to master negatives of a film. It is a really important contextual background that these schemes have nothing to do with the film itself. It doesn't matter what the film is. As long as it ticks some boxes, it has to be the right kind of certification. It needs to have a budget above or below something. It needs to be made or not in the UK. So there are these sort of characters or qualifications it has to have, which are laid out in the legislation. The scheme is designed in such a way that the taxpayer and the promoter of the scheme who use or kind of plug in the film to the scheme have no control, no interest, no nothing. They can't influence in any way anything to do with this film. The purpose of the scheme is to give the film producer, say out of 100, 15, and for the taxpayer to only lose 15, but for then to the exchequer to give tax relief on 100, as if 100 had been spent to the taxpayer. So the only people who lose out in these schemes is the exchequer. So the film itself is not, this is not really about choosing films or identifying films. It's much more like going to B&Q, I was thinking, with a shopping list and saying we need a bag of nails of this length with this whatever specification, and we need some steel poles or something, and then you pick them. Now and this is in effect what the first tier found, if the cost of getting your agent to go and buy these items on the shopping list is sort of so incidental to the acquisition, it's sort of subsumed into it, you'd say, well, it's on the provision of, because it's a bit like the transport costs, then so be it. But that's the region, and that's the sort of facts that we're talking about. One of the films, Oliver Twist, was already being used in another film scheme by the same promoter. So I suppose they already knew it ticked all the boxes. So I would say that it just doesn't contribute much to the analysis or discussion. The case was really about whether you could pull the rug from all of these tax schemes on the basis that the transactions didn't amount to a trade. Because if there's no trade, there's no relief. The schemes fail. And the first tier, and it went to the Court of Appeal on that basis, the Court of Appeal upheld there was no trade. And that was the fundamental and really important point about this. And that's why Samarkand is an important case. But that is because it decided that. And the first tier was deciding the fees for the identifying the films and negotiating the contracts. Simply, in the case I'm wrong and you were trading, then you would have got relief on this, but not that. But the fact is, they never got this relief because there was no trade. So it was just well, if I'm wrong, here it is. And then the revenue didn't appeal, but one doesn't know why they did or didn't appeal, but it's not important. Like, objectively, it's not an important point in the context of that litigation and what the case decided.
So the point was only dealt with at the FTT level, is it?
Yeah. Now, just very briefly...
I'm sorry, my Lord's question was whether this point was only dealt with at the level of the FTT.
Yes. Sorry.
Right.
Yes.
Yeah.
Well, that's helpful. Thank you.
And it's true the revenue didn't appeal, but then the revenue can't appeal and argue out everything and make... Well,
sorry, I didn't hear that.
Well, the revenue didn't argue it again in the upper tribunal. But I was saying that's just a litigation decision and we can't go behind that.
Because the important point was whether this was a trade.
Well, I would say so, yes.
Yes.
Final point, just to make sure I've ticked off the cases and points relied on my learned friend. I think I've dealt with the plant and machinery manuals, and the point is exactly... The point is kind of picking up that language of Lord Wilberforce, is that the revenue's view is those manuals are actually very narrow and they would certainly cover the professional fees in the course of the construction. But they don't go wider. And of course, in the end, these are the manuals. And this isn't a judicial review case. And actually, it's too generic. You couldn't, I don't think, found a judicial review on what's said in the manuals. They're not sufficiently clear. But in any event, we say they're consistent with our case. And then the structures and buildings allowances manuals. In my submission, these just cannot be helpful because they're the manuals, which are of themselves not aids to statutory interpretation, for a different bit of legislation. It was introduced after a hiatus. The industrial buildings allowances legislation was repealed. There was 2 or 3 years, and then this new reworded regime was introduced. Now, it's much more prescriptively. There's much more drafting in this. There are statutory deemings and statutory exclusions. And in the end, that's excluded. And to rely on the manuals in relation to that code, I think, is just absolutely a step too far. I mean, and I'll see what my learned friend says about it, but I don't think it's of assistance. I mean, I could say that the intention was not to go beyond the plant and machinery manuals, but I think even that's overstepping the mark as to say what, or they're relevant. So if I can hand over to Ms. Parry, just to put our legal arguments in a factual context. And there are just 1 or 2 points that we need to answer in my learned friend's
Yes. I should say that if you want to, you can use up some of your reply time.
Oh, thank you. Yes.
You can mortgage it.
For more issues.
You can't redeem it.
To make sure we've
You
covered.
can't redeem it.
I'm very grateful. Thank you. So I'll just swap.
Thank you, Ms. Wilson. Ms. Parry.
Thank you. And Harriet Parry, also appearing for the revenue. I am going to try and make 3 points quickly, ideally without getting into a mortgage situation. I'm going to speak to design, final drawings versus design process, then the issue of directly related in the context of the first tier's test, and lastly, I'm going to speak to where, on the facts as found by the first tier tribunal, where the revenue would say the line between qualifying and non-qualifying should be drawn. And that will involve a little bit of factual analysis at the end. Turning to design, first of all, I think it's clear, and my lady very helpfully encapsulated it. Design is both a noun and a verb, and there is a distinction between the design process and a design in the terms of the final technical drawings, and indeed design has been used in other senses in the course of this case. We are talking in this case, largely as to whether the costs of the design process are qualifying, and we can see that clearly referenced in paragraph 72 of the Court of Appeal, which is at page 175 of the bundle, and it says in the first sentence, of course, for the most part at least, the present appeals do not relate to the costs of the drawings of the generation assets or their components, nor even to costs incurred in relation to the computer modelling, which was evidently used in the design of the wind farms. It is Orsted's case that it is entitled to claim allowances in respect of studies, which, while they may not themselves have contained designs, provided information which informed the design of the generation assets.
So just why do the present appeals not apply to them? It could be because they didn't claim deductions for them, or they did and HMRC accepted that those were deductible, or it was decided they weren't earlier and that was an appeal. Why do the present appeals not relate to the costs of the drawings?
I cannot tell you exactly why that is the case, because the focus has been on the process and claims for the process insofar as I understand it. What I can tell you, and I was going to address this when dealing with where we draw the line, is that there is a paucity of factual findings in the first tier decision as regards exactly the process of who did what and who paid for what in the process between the first technical drawing and the last technical drawing. And I'll take you to where that is dealt with in the first tier when I get to the point about design.
But here we're concerned with studies.
Here we're concerned with
not the drawings.
Yes, at least in the main, according to the Court of Appeal. The point is also made very clearly in the upper tribunal at paragraphs 162 and 163, which is on page 225 of the bundle. And here the upper tribunal helpfully draws a clear distinction between the process of design and design as an end product made real in substance. And it says at 163 here, the design costs in respect of which relief is sought are those arising in relation to the process and the data gathering to inform the design process. And it emphasises there that it can be an iterative process. And before I move on to the next point, what I want to emphasise, apart from the linguistic difference, is that the nature of these two aspects are different. Obviously, a final design, a technical drawing is one thing, but the design process itself is different, advisory, data gathering, and it is iterative, as we see there in 163 of the upper tribunal. Much of the expenditure on the studies and surveys involved in that process would have been spent regardless of whether any plant eventuated at the end of the day. And we know that, and again, this is relevant to the drawing of the line, which I'll come to. We know that because the final investment decision taken by the companies comes late, very late in the process, and I'll show you where by reference to the first tier tribunal at paragraph 32.
I mean, I don't know whether that is a date which is in their control. One would be hesitant to make that a cut-off if it was capable of manipulation.
Well understood, and I'm not suggesting per se that it is the cut-off. What I am saying is that it is not until that point that the companies themselves are even finally committed to having the plant. But in the process, and this is picking up on the test that my Lord Burrows, you suggested earlier, whether or not expenditure is incurred even if plant doesn't eventuate. even on the company's own internal processes, they may not have made a decision that the plant will finally eventuate until late in the day. And similarly, the certain studies and surveys making up or feeding into or informing the design process will be undertaken whether or not there is ultimately plant, because they are undertaken for other reasons, objects or purposes. For example, the studies going in to make up the environmental impact assessment are undertaken to gain regulatory consent, and yes, they provide information on mitigations which may feed into design, but it is possible, it wasn't the case here, but it is possible that regulatory consent might not be granted to the particular project. And so that was
the final investment decision would be taken at quite a late stage.
Yeah, absolutely, and we'll see.
It'll be certainly maybe after the regulatory consent.
Absolutely, after the regulatory consents are granted, yes. And I will show you exactly in the project life cycle by reference to the first tier findings. So that's my point one. My point
just
two,
before you leave that,
yes.
Am I right in saying that the revenue are not committing themselves to whether final designs would or would not be covered?
Certainly on the facts in this case, we can't commit to that because of the facts that have been found or not found.
You cannot commit to that?
We cannot,
yes,
because of the facts that
thank you.
Have or have not been found. In this case, it's more a matter of what hasn't been found. My second point is in relation to the first tier tribunal's test of directly related to necessary design or directly related to safe and effective installation. These are phrases that you will see frequently referred to in the statement of agreed facts and issues, but it needs to be made clear neither side accepts the necessary or unnecessary design test put forward by the first tier. It was never argued for by either side. But you can't then, as my learned friend may imply that you should do, you can't then go through deleting the word necessary and adopt a new test of directly related to design. Why can't you do that? Well, we say you cannot do that because of the following. The first tier's test was a composite test. It involved its own version of hindsight, because the test as applied by the first tier was not applied at the point that the expenditure was incurred, but when the taxpayer saw the outcome of the survey or study. So the taxpayer would need to see what any study suggested or recommended, or whether there was a nil return, before it could decide if this was qualifying expenditure. If you want an example of that, I'm very conscious of time, so I won't, I don't think I'll read you the whole paragraph, but if you wanted an example of where you can see this, paragraph 169 of the first tier at page 283 of the bundle. And here it's talking about the benthos studies, benthos being organisms that live on the seabed. And here it said that the benthos studies for WODS made certain recommendations as regards which of 3 development options under consideration for foundations was the least harmful to benthos. Meanwhile, the other benthos studies, the the first tier found, didn't make recommendations about design going to benthos. There may be a bit of a debate about that in relation to Gunfleet. But the point being that the first tier's approach involved getting the study survey, seeing what it said, and only then.
Did the first tier come to a different decision as to WODS rather than the others then?
Yes. So that's the first point. The second point is the necessary or unnecessary design. No one argued for that. And the third point is that directly related is a
I'm sorry. The second point again, please.
Is necessary, unnecessary design was not a test that either side argued for.
Yes.
And yet it was a test that permeates the first tier's judgment. Third point, directly related is a gloss anyway on the statutory words. This does not mean, contrary to what is suggested in the company's written case, this does not mean that the revenue is seeking to disregard the findings made by the first tier. Quite to the contrary, what we say on this side of the room is that you actually need to look to the granularity of the facts found rather than the erroneous test which the first tier tribunal created and applied. And in all the first tier's conclusions are infected with these problems, and therefore their conclusions, as opposed to the underlying facts, their conclusions cannot sensibly be relied upon, whereas, of course, we can look to the underlying facts that they found and which they applied their conclusions to. Now, I've said I will address you on where the revenue says the line should be drawn. I would be very grateful if you could have available to you the first tier judgment, paragraphs 19 through 33, which you will find in the bundle at pages 249 to 252. This section is entitled Steps in Developing an Offshore Wind Farm, and it sets out what one might call the life cycle of the project up to the point of installation. It's pages 249 to 252 of the bundle. It is necessarily at a high level and is not the specific findings in relation to each of the wind farms subject of this dispute. However, I refer to this section because it doesn't involve the references to the erroneous necessary or unnecessary design test. It is meant to be a sort of fairly neutral summary by the first tier before the necessary or unnecessary design test comes into being. Oh, and one further point about the necessary or unnecessary design test. The first tier also propounded a test about safe and effective installation, and it is worth re-emphasising that the concept of safety was relied on by the first tier in relation to the natural world and all flora and fauna. So we can see, for example, at paragraph 170 of the first tier, safe here being safe for the perspective of Benthos. I just needed to cover off that point. Coming back to paragraphs 19 through 33, where do we say the line should be drawn? Well, we put it that revenue puts the line in paragraph 32. So if you turn to paragraph 32, and I would have gone through all these paragraphs, but in the interest of time, I'm truncating what I was going to say. If you go to paragraph 32, the revenue would suggest that the line could sensibly be placed after the second sentence and at the start of fabrication of the wind turbines will then commence, and so too will their installation. During the installation, there may be further investigations to ensure up-to-date information is obtained on certain matters relating to safe installation, for example, information on unexploded ordnance. Why, you may ask, do we not put the line...
So wait a minute, you're saying that if there are updating surveys during installation, then those would be covered?
Yes, now this was a point that was discussed before the court, I believe before the Court of Appeal, that it was said if a survey needed to be undertaken by those installing, to check that there were no hazards, to check that there was the unexploded ordnance hadn't moved or something like that, then necessarily that would be part of the process of installation if done when the plant is in sight and you know that you are installing this plant. And that is the distinction there between an unexploded ordnance survey being undertaken during installation and one being undertaken, for example, as part of original geophysical or geotechnical studies with a view to establishing whether the site is suitable in and of itself for having a wind farm or whether exclusion zones need to be set up, etc. From the comments and questions earlier today about the issue of the design drawings, it may be that there may be people who would say you could draw the line, for example, in paragraph 31 about the design drawings. But A, we've been discussing the design process, i.e. the studies and surveys being dealt with up to paragraph 30. And B, we simply do not have the factual findings available to us in this case to know exactly who was doing what in relation to the final drawings. So we see there in relation to paragraph 31, it says detailed designs for the foundations are then compiled, following which Orsted goes into the market to find a manufacturer for the fabrication of the foundations and transition pieces. Orsted carries out no manufacturing itself. And then it says, once a manufacturer has been identified, the parties liaise about the design and the technical drawings. And then in paragraph 32, we know that contracts with suppliers are only signed off after the final investment decision. So we don't actually have findings as to who did what in relation to the technical drawings in that process of liaising between the manufacturer.
So none of the items in dispute, none of the items in expenditure relate to what would be in 31?
I would have to seek instructions to confirm, but the bulk of our discussion throughout this case has been in relation to the studies and surveys that inform that process in 31.
Going back to 32 for a moment,
yes.
You suggest that the line might be drawn at the point of when fabrication of
yes.
the wind turbines commences.
Yes.
How can fabrication commence when there are no detailed designs?
As a matter of fact, there have to be detailed designs to fabricate the drawings. We don't deny that. It is about where you draw the line for the purposes of the statute.
But the trouble about that is that it might be that the same expenditure would be allowable if it was incurred after the FID, but not if it was incurred the week before.
I'm not suggesting that we take the final investment decision as the cut-off. It is picking up the point my Lord Burrows said this morning about what about expenditure which would be incurred and the plant never eventuates.
Well, of course, then you don't get your allowance. So.
There isn't even a decision by the companies.
No, but I mean, you've got to end up owning the plant.
Yes, and why we therefore have placed the line at fabrication is because at that point the plant is in sight, the plant in question.
Are you saying that any expenditure before fabrication is not allowable?
No, there may be expenditure that is allowable
so
in the final drawings, but
the FID doesn't provide a point at which we draw the line, does it?
We place the line where the plant is in view on the facts that we have, that the actual plant in question is in sight. On the facts that we have here, we don't have sufficient information.
No, I understand that you can't
yes.
make any concession, as it were, about any of the, the later design process or the designs. I understand that entirely. All I'm querying is whether really the FID is an appropriate line
No,
to
and
draw.
I'm not proposing the FID. No,
So what you're saying is when you know what you're fabricating.
yes, it is when you know what you're fabricating and you know the actual plant in question that you are getting. And it may be that there are further tweaks and amendments to the actual plant once fabrication has started. We don't have evidence of that, but on the basis of trying to give a test that works based on the findings that we have, the line is around the time when the actual plant is being made.
But, I'm sorry to be awkward about this, but I mean, you've told us, and I fully understand this, you do not have the findings about the designs. So you can't draw a line at the moment. Because as I understand it, is this right? There's going to be further hearings about the designs? I mean, or I don't understand the position here. Because we were told that no concessions can be made about the designs because we don't have the findings. Is that because there are never going to be any findings, or because the findings are going to be made at some future hearing?
Well, I think the first point would be that if there is a ruling on the principle from this court, one would hope that the matter could then be resolved.
Well, I'm not sure about that, because we're not directing ourselves to the areas where there are no findings.
Then the point becomes a sort of a twofold one. If there is an individual issue where this court considers that it can't reach a decision due to the problems of the first-tier tribunal's test,
well, I'm sorry, Lord Burrows asked Miss Wilson specifically about design costs, and the answer was that, and I understood the answer, she was not able to say yes or no to that because there aren't the findings. That's the difficulty I'm having with this at the moment.
I think that this case has always been run as asking the court for a decision in principle, so that we've never had detailed evidence about the line items of expenditure. And in the end, the burden of proof is on the companies here. So if we've got, in fact, there are files and files of the studies and assessments, and none of those contain the final drawings. So I think my understanding is if you're asking for a decision in principle, we're given a decision that's then applied to the expenditure on those studies.
Right, and which side? So you're drawing the line at fabrication of the wind turbines, and that's a line in principle, and that's useful to apply to this case because actually all the items in dispute are very clearly on one side, very far on one side away from that line, whereas there may be a different case in which that line has to be applied to detailed drawings, but that case is not this case, is what
correct, subject to one qualification, which is that paragraphs up to 33 of the first-tier tribunal don't encapsulate a third round of geophysical and geotechnical studies, which is referred elsewhere in the judgment. They don't refer to that. Those can happen during installation. The upper tribunal did not allow those, and we say on the factual evidence that was available to them in this case, that was a legitimate decision. And if one looks at the chronologies, one can see that on the chronologies of the facts for these wind farms, none of the detailed geophysical and geotechnical studies are listed as happening during the construction process. They're listed as earlier. They're listed as pre-FID, except in the case of Gunfleet Sands. They're not listed as happening during installation.
I'm just a little bit concerned about we're being asked to decide something in principle. I mean, I thought the issue on this appeal is whether these various items of expenditure are or are not allowable. I mean, that's not a decision of principle. It may be based on principles, but it's a specific decision, just as it was in the two previous House of Lords cases.
And I think that's right. And I've always thought that.
Good, good. Yes. I mean, of
companies
course,
are very...
issues of principle arise on appeals to this court, but it's not, as it were, some preliminary ruling. It's a final ruling on those items of expenditure, isn't it?
No, and I think,
Okay.
yes, I think...
Well, we're not to say anything, as I understand it, from your point of view, about the design costs incurred in this case, the ones which are more related to the plant, of what's referred to in 31. Because your answer to Lord Burrows was, well, there aren't the relevant findings that can be used.
Yes, I think in relation to design costs generally, we say they're the wrong subject matter of the expenditure.
Sorry, you say that they're
So,
in relation to the costs of the design process, they are by process meaning all the studies and surveys, and that is what this case has always been conceived as being about throughout its history. We say that those are non-qualifying, and as regards the costs of the final drawing...
The point about that is, of course, we don't know, we've got no findings on that.
But that was the point I was making, and that surely is what is referred to in paragraph 31.
Yes.
Yes.
I'm sorry.
No finding. That's an area we shouldn't get into, you say.
We haven't got a finding as to what the process was there.
Okay.
And so far, the studies which are still in dispute, so not the desktop scoping ones that were knocked out, I think they've all been treated as either they're all in or else they're all out, rather than going through looking at exactly which one does what. And is that what both sides are saying, that either that actually the ones that are still in dispute, they are all in the same space, whichever side of the line it is, they will occupy the same distance from the line, and so either they're all allowable or none is allowable. It doesn't matter whether they're about birds or ordnance or benthos.
I mean, I think our case is, well, it must be right that it's a line item of expenditure by item of expenditure.
Yes.
So you can't deny one item because some other study has not been allowed. So it has to be study by study. So it is possible that if you were to accept HMRC's approach, that you then read the upper tribunal's decision, you say, well, I know that they found that all of the studies were on the wrong side of the line, but maybe we think that those studies, it's more difficult. But, I mean, the upper tribunal applied, in effect, HMRC's test, and it sets it out, I think, from 182 onwards. It disallows each and every study, looking at it separately by reference to its test.
So your case is that none of them qualify. Respondent's case, all of them.
Yes, it is. It's always been quite polarised in that.
Unless I can assist you further.
Thank you, Ms. Parry. We're grateful.
A few minutes.
James.
Could I please start with some context, factual context? The court will have seen that, as one might expect, the process of designing and fabricating and installing a wind farm several miles out at sea is a very complicated and time-consuming and expensive one. It takes several years and many millions of pounds to complete that kind of project. Now, it is not easy to convey just from the documents a full sense of the difficulty and complexity of that undertaking. But I hope you will have seen within the statement of facts at Annex 2, this is page 54 of the bundle, we had included some diagrams and some pictures. Now, the FTT had a site visit to see the one of the wind farms. There was also various videos and so on presented to the FTT. This is just a snippet of what was before the FTT. But if you have page 54, you'll see there at Annex 4, some of the turbines, this is in the bottom picture, some of the turbines in the array at Gunfleet Sands, and that's located 7 kilometres off the southeast coast. And for some sense of scale, each of those blades on the individual wind turbines there is around 50 to 60 metres long. Now, those turbines have been arranged according to a precise design, which needs to be worked out by the company by reference to a number of different factors. They are not just plotted anywhere in the sea at random. Now, obviously, what you can see in that picture is only what's above the surface. There's a lot more going on below the waterline. And if you could turn forward to page 56, there are two more diagrams in Annex 6. The top one shows one of the wind turbines a little bit closer up. Some of its component parts are labelled. And the second diagram shows what's going on below the waterline. And I hope the court can see there the monopile foundation that has been literally hammered into the seabed. And that relatively simple looking item there is essentially a bespoke steel tube that is hammered many metres into the seabed in order to ensure that the massive turbines are stable. And if you wouldn't mind just turning back to page 55, there's a plan view there in Annex 5. And that's a plan of the west of Duddon Sands wind farm. That's an array which is off the northwest coast of England. Now, it may be a little bit too difficult to see, or possibly your lordships and your ladyship might be able to zoom in, but if you look very closely, there's a little blue letter and a number on that plan, and each one of those is a specific wind turbine. And connecting those up is a dashed red line, and that's the inter-array cabling. And it's that configuration, that array, so all of the turbines and the cables which connect them, that have been labelled collectively as the generation assets. And that array comprises a single item of plant. So that is the plant that we are looking at in this appeal. That was the conclusion of the FTT and then the upper tribunal in this case, and HMRC subsequently accepted that that was a single unit of plant. Now, it's a single unit of plant that expands in this instance across several square miles. The shape of that array, that configuration of those turbines and the cabling, is therefore part of the physical characteristics of that item of plant. If one changes that configuration, then one is changing the physical parameters of the plant. Now, of course, the process of designing and then constructing an item of plant of this size and of this complexity, several miles offshore, requires a large amount of information about the environment in which the wind farm is to be constructed. One has to understand the detail of the metocean conditions, the conditions as to the winds and the waves and the currents at the site. One also has to understand what's going on the seabed and underneath it. And it requires an understanding of the other environmental factors to which the item of plant will be subject and which it could affect. So this item of plant, a bespoke item of plant, has to be designed before it can be built. And it has to be designed so that it best fits the environment into which it's to be installed. And that design process is itself a complicated one that involves gathering information about the environment into which that wind farm is to be installed, and about how the physical characteristics of that item of plant need to be adapted so that it best fits that environment. That's the process of design. There's also the process of installing and constructing this item of plant out at sea. That in itself is very complex, and it's informed also by the data that's gathered about the environment into which it is to be built. Now, in addition to being very complex and very time-consuming, it's also very expensive. There's the costs of the physical components, the turbines and the cabling and so on. HMRC accept that all those costs qualify for capital allowances. What's an issue here is, by comparison, a much smaller amount of costs that are concerned with gathering data and information about the environmental factors that will affect the design and installation of that item of plant, and on gathering information as to the physical characteristics that the plant should possess in order to ensure that it best fits the environment into which it will be built. Now, the key, of course, is the legislation. Section 11 is really the focus. That's at 411 in the main bundle.
Can I just ask you this before you take us there? In Annex 5, we've got the field, as it were, in green,
yes,
which is the location of the wind farm. Is a license or something granted by the Crown, by the Crown Estates, the government? I mean, my question ultimately is going to be, is this the only area? Is it, you first of all you're allocated, as it were, this area, and then you have to decide whether, and if so, what wind farm you install there? Essentially,
yes. I think there's a process of bidding for polygons.
Yes, and that's what I was wondering. Yeah.
Yes, this is covered in the findings in the FTT. There's
right.
a process for bidding for a polygon. Eventually, there'd be a lease granted by the Crown in respect of that area. You would put your bid for this area, let's say, is accepted. So, I mean, maybe at that stage there is, as it were, an agreement for a lease or something of that sort. But this is the area you've got to play with. Yes, essentially. But within that, Your Lordship might notice that within that, the turbines are not set out in identical rows.
No.
There's actually a gap in the middle. See where there are no turbines, in the middle and then towards the south of that area. Now that, in this particular instance, that's because it was found upon performing one of the surveys about which we are now arguing that there was bedrock in that area, which meant that you couldn't put a turbine into the ground there.
I see.
So this goes to illustrate how these surveys impact the particular item of plant that ends up being constructed and installed there. So yes, it's true that you have that polygon to play with.
Yeah.
But within that, you
yes.
have to design the item of plant that's going to fit within that area.
And the items, the surveys and so on with which we are concerned, were they carried out with the liability for them incurred after the companies had been allocated this plot on, as it were, I mean, the price for it and so on had been agreed? Had they incurred a liability to the Crown or whoever it is to take a licence of this area?
It's difficult for me to answer that off the top of my head because one has to have reference to the chronologies which are at the back of the statement of facts and issues.
Right.
And they set out the different dates at which these various things happened. So there is, if one takes page 41, the chronology for Gunfleet Sands.
Yes. Do you know what a TWA order is?
I ought to know that. There's also a glossary. I think it's a particular kind of consent.
So the 4th of April 2003, there's an agreement for lease for Gunfleet Sands.
Yes. Now, before that, in 2002, there's an application for a TWA order, which is accompanied by an environmental statement.
Yeah.
And that's referred to in the dispute as an environmental impact assessment. Now, some of the studies, not all of them, but some of the studies are carried out in order to, or as a part of the undertaking of that environmental impact assessment. But the meta-ocean studies and the geophysical and geotechnical studies have nothing to do with that process. And so Your Lordship will see that in 2002 there's an application for the order. 2003 March the consent is granted, then the agreement for lease is entered into. And it's later that then one gets over the page 42, the first round geotechnical studies in September 2003. And then there are later more detailed studies involving meta-ocean studies and geophysical and geotechnical studies in 2007. So these things happen over a period. And just on the point of the consents, my learned friend had repeatedly made points about this. It's important to understand, and one gets a sense of this when one looks at the facts that are found about what the studies do. The consent or the environmental impact assessment does not exist in the abstract. It's not there for its own sake. It is there to ensure that the wind farm that is to be installed is best fit to the environment. That means that you minimise the impacts on the environment of it. And that means adjusting its design so that it best fits. An example is the bird study, the ornithology and risk study, where one of the things that's checked for is the flight heights of the birds that will cross the site. And if necessary, the heights of the turbines will be adjusted to take into account the flying heights of the birds that cross the site. And that's an example of how an environmental factor, which is then studied, can impact on the design of the item of plant that's to be installed.
Just, sorry, if you finish that point, just going back to 55 for a moment, the grey area to the northwest of the green area, is that a pre-existing wind? That's a pre-existing wind farm.
That is also one of the wind farms in this appeal. That's Walney, but it's greyed out because this is just showing west of Duddon Sands.
Right, but all those little dots are also turbines, although some of them don't seem to have array cables attached.
Well, I think if it were in colour, it might well show it would perform to the key to the right-hand side. But I think the reason why this is in colour in the middle is that it's just showing the west of Duddon Sands wind farm. But your ladyship might notice that the turbines in the Walney farm are laid out in lines. They're not affected by that bedrock issue, which affects west of Duddon Sands. If I could then just move to the legislation, please. 411 in the bundle. The question at the heart of this particular issue is whether the expenditure on the various studies and surveys, which contributed in different ways to the design and construction of the wind farm, was expenditure on the provision of that plant, that item of plant that I've described. Ultimately, that's a question of interpretation and application of the statute, although there is some guidance in the existing case law. I wanted, if I may, to make 5 points about the legislation. And the first concerns its provision, its purpose. It being common ground that it needs to be given a purposive construction. As noted in the company's written case, at paragraph 118, there are two purposes at work that can be identified here. The first is that there are different types of capital allowances available. We are concerned with plant and machinery allowances. The purpose of those allowances has been identified as being to incentivise investment by businesses in plant and machinery. That was observed by Lord Hailsham, Lord Salmon and Lord Russell in their speeches in Benedetto, and the references are given in our written case at paragraph 118A. And the second purpose that can be identified is that of the allowances regime as a whole, which my learned friend had touched on in her submissions this morning, which is to ensure that traders are taxed on their true profits. Now, in order to be true, those profits have to take account of the depreciation of capital assets that are used in the trade. And that wider purpose was identified by Lord Nichols in BMBF and Mawson, which my learned friend took you to, or showed you an extract from this morning. Just on the point about those purposes and the interplay between depreciation and the allowances regime, there were 2 points that were floated this morning, which I don't think had appeared before in argument in this case. First of all, a point about replacement. And my learned friend said, well, if the turbine fails and you have to replace the turbine, you don't necessarily have to carry out another study about the benthos. Well, as to that, actually, I don't know what the answer to that is. That's never been a question that has been raised before. It may well be that you have to carry out another study because the conditions might have changed. But in any event, there are 2 points which show why it's wrong. First of all, on the terms of the legislation, the taxpayer gets allowances whether or not there is any intention to replace the item of plant if and when it wears out. Allowances are available if they use an item of plant once and they don't replace it. There is no condition in the legislation or in the case law to suggest that one has to look at the intention of the taxpayer as to whether they would replace it if it wore out. Second point, in relation to whether or not you'd have to do another study, of course, if one thinks about Barclay Curl, the company doesn't have to dig the hole again if they have to replace the dry dock. No suggestion that that was any kind of barrier to the expenditure on excavation qualifying for capital allowances. And then related to this, or in the context of these submissions, there was also a point that my learned friend floated, I think by way of touchstone, maybe no more than that, looking at whether the costs in issue would feature in the disposal proceeds of the item of plant at the end, if the item of plant is disposed of. And as to that, I think as was observed in argument, that is also not a relevant consideration, and we can know that because it is accepted on all sides, has never been disputed, that the costs of transport, for example, qualify. There's House of Lords authority to that effect, and yet it's difficult to see why the cost of transport would feature in the disposal price of an item. But again, there is no barrier to expenditure on transporting the plant being qualifying. So really that point, that supposed touchstone, is an irrelevance. With respect. Just coming back to the purpose of the provisions, as regards them, there is no doubt that the companies incurred the expenditure. It's been capitalised in their accounts. That's recorded in the FTT's decision at paragraphs 83 to 89. That expenditure was incurred as part of the process of designing and building the wind farm. And that wind farm was the apparatus that the companies used to generate their trading profits. So this was expenditure that had to be incurred by the companies so that they could obtain the plant, without which they couldn't generate their taxable profits. Now, the upshot of the revenues position is that despite this, the companies would have no deduction whatsoever for this expenditure, which the revenue themselves describe as genuine business expenditure. It's a term from their written case at paragraph 77, in computing the taxable profits of their trades. As the court may have seen, the companies argued below that in the alternative to capital allowances, the expenditure in question ought to be deductible as pre-trading expenditure. The revenue successfully defeated that argument at every level on the basis that this expenditure was capital.
But what I mean, so you're saying there can be no expense which is not deductible?
I certainly don't go that far, my lady.
And you're supposed to recover the costs from generating and selling electricity. So why should you recover the costs from the Exchequer?
Well, one could say that about capital allowances generally, because of course capital allowances always have to relate to capital expenditure in fact.
Yes, but you seem to be making a point that it's unfair somehow that because you've genuinely incurred this expense, you should be able to deduct it from your profits.
Well, I don't say that it's an impossible result that there is no deduction whatsoever, but in my submission it's a surprising one, because this is expenditure incurred to acquire apparatus which is used to make the taxable profits, and yet on the revenues case there is no deduction whatsoever of any kind in computing those profits. And in my submission that would be a surprising result, and it would mean that the companies were not taxed on their true economic profits. It would also act as a serious disincentive to investment in plant and machinery of this kind and of infrastructure projects of a similar nature. My second point, just looking at the language of the section, we know that expenditure qualifies if, amongst other things, it is on the provision of plant or machinery. It's important to recognise, as the FTT did in Samarkand, it's not expenditure merely on the plant. It encompasses expenditure on its provision, which is a wider concept. And also, importantly, in terms of context, set out in the written case, it's important to keep in view that what can count as plant can vary enormously. In the case law, there are examples. One of the most famous cases, Yarmouth, it's decided that a horse is plant. In Inmarsat, case my learned friend took you to, the plant was a satellite that had to be launched into space in order to be usable. You have a dry dock in Berkeley Coal. You have a wind farm in this case. You could have something as simple as a monitor. There's a huge variety of items that can count as plant. And that thing could be off the shelf. The thing could be bespoke. And it could be something that's as simple to install as a printer or as difficult to put into use as a satellite. But the same section applies to all of that range. And the statutory language has to be interpreted and applied in a way which will allow it to apply to that whole range of plant, from the commonplace to the unusual, from the off-the-shelf to the custom-made, to the item that takes minutes to install and the item that takes years to install. And it has to be capable of applying to all of those things. And just as the items that can comprise plant or machinery can vary extremely widely, so too what it takes to provide them. And it's common ground, as I understand it, that the term provision includes both the acquisition of something which is already in existence or ready-made, as well as the construction of something. Now, I'll need to come back to the case law that's looked at the scope of the statutory words, expenditure on the provision of plant, in due course, but just as an overarching point at this stage, I submit that the legislation has to be approached with that scope and with that context in mind. And it's perfectly possible to apply the legislation in that way, because the term on the provision of is, in my submission, an elastic one, to borrow a term from my lady's judgment in SSE, which is capable of applying to that range of circumstances. The third point I wanted to make, again looking at the language of the section, is that there is no requirement that the expenditure be necessarily incurred. And one can contrast that as a matter of the provisions of the tax code with section 336 of the income tax Employment Tax Code, which is at page 462. This is section 336 of the Income Tax, Earnings and Pensions Act 2003. It's part of the Employment Income Tax Code. It sets out the general rule for the deduction of expenses against taxable earnings. And the court might note that the general rule is subject to requirements in A and in B, and B is that the amount in question is incurred wholly, exclusively and necessarily in the performance of the duties of the employment.
So you might, legislation might require a certain set of safety checks on a piece of plant. Carrying those out clearly would be necessary. It must comply with the law.
Yes.
But the company acquiring the plant may decide voluntarily to undertake some further tests. They would be wholly and exclusively, but not perhaps necessary.
Yes, that's a fair example.
It doesn't tell us very much about what is expenditure on the provision of the item, except to say it doesn't have to be necessary.
Well, that's
the
only point that I want to establish at this stage,
all right.
Which is that where Parliament does want to impose those kinds of restrictions, it does so expressly. And in fact, it has done so expressly within the code that we are concerned with.
So is this part of your argument that it's not, there's no necessarily test? That's why you don't adopt what the FTT said?
Well, there's that point, my lady. And as my learned friend said, neither side actually urged the limitation that the FTT identified for itself in relation to that. But it goes slightly further than that, which is that at certain points, certainly in the written case, HMRC say that the term expenditure on the provision of plant is limited to, I think sometimes they say mere installation or something that's needed. Essentially, it's the bare minimum amount of expenditure to make it basically usable. And in my submission, that goes way too far. If we contrast, or we can see that there's a capital allowances equivalent to 336 within the Capital Allowances Act itself. If the court would turn to page 427. I hope there you'll see section 36. Now, this is within the same part of the same Act that section 11 sits in. Now, this is dealing with instances where the qualifying activity is an employment or an office. So you have various different types of qualifying activity. Trade is one of them. That's the one that we are looking at. But where there's an employment or office, there is a further restriction. And it's a restriction on the general rule. And the focus of my point is on 1B. Other expenditure is qualifying expenditure only if the plant or machinery is necessarily provided for use in the performance of the duties of the employment or office. So, if an employee, as opposed to a trader, purchases an item of plant or machinery as a matter of choice, simply because he or she wishes to go about their job in a particular way, it will not have been necessarily provided for the purpose of the section. It has to be necessary according to the role that the employee carries out. But again, the key point that I seek to make is that where Parliament wants to impose that kind of restriction, it does so expressly. But in section 11, there is none. There's no inquiry into whether the particular item of expenditure was necessary to incur. So going back to my Lord Richard's point about additional checks that the trader wishes to carry out for good commercial reasons, one would expect, there's no inquiry into whether that was strictly necessary. And one sees that in other areas of this part of the law. I hope the court will have seen references in my written case to the concept of preliminaries, which is accepted on all sides as being a category of qualifying expenditure. Within that, there are various different examples, one of which is insurance in relation to the site when something's being constructed. The revenue give other examples. Scaffolding is one, site security is another. Now, when one looks at the strictness of the revenue's position in this appeal and compares it with existing features of this area of the law, like preliminaries, one sees that there is an inconsistency. It is difficult to see how insurance or expenditure on insurance can be said to affect the provision of an item of plant.
Well, what are you insuring as a part of a preliminary?
One imagines it's the site, but insuring anything does not affect the provision.
I suppose if the installer says that he wants insurance for his equipment while it's on site, that would be a necessary cost, actually a necessary cost, but it would clearly be part of the cost of installation, because you need a specialist installer, and part of his price is insurance for his equipment.
But there's no sense in which one goes to that and says, well, how did insurance affect the provision of the item?
No, but it's a part of the installation, isn't it?
Well, it may be that that's a cost that the installer has.
Scaffolding. I mean, you may not be able to erect whatever you're erecting without scaffolding. So it's part of the installation.
But then if you have a cost which is part of the necessary process of designing the item.
Well, we're moving away. Installation is, I think, a pretty well accepted item, isn't it?
Well, that raises
right.
a question, because it is accepted as an item, but one then has to understand what the scope of that is. Now, to my Lord's point about perhaps if the installer insists on having insurance in place before effecting the installation, why should that qualify, but the cost of checking for unexploded ordnance before hammering the foundation into the seabed not qualify, which is the revenue's position?
Well, they are rather different.
But one could be said to be critical. In fact, the finding in relation to the by the FTT in relation to checking for unexploded ordnance is that that is vital to the safe and effective installation of...
It depends on how broad provision is. That's what we're talking about. I mean, you could say when you're sending your big piece of kit on the road to be installed somewhere, I mean, these 50, 60-metre blades had to be presumably brought somewhere on the back of a lorry. Presumably they had to be insured whilst they were being driven along or sailed on the boat out to the tower. But that's part of the installation and the transport, isn't it?
Well, it absolutely is a question of how broad is the concept of provision. The point I simply make about that is, if provision is broad enough to encompass site insurance, which is the revenue's accepted position, then it ought to be broad enough to cover the costs of designing the item so that it could be created.
I don't think it follows necessarily, but
well, that's
anyway, your submission is that they're indistinguishable.
I don't say that they're indistinguishable.
Or that well, you're saying it's inconsistent.
It's
to allow
inconsistent.
one but not the other.
Absolutely.
So that must mean that they're indistinguishable, isn't it? Because if you can distinguish them, they're not necessarily inconsistent.
Well, I would say that they are distinguishable in the sense that the costs of designing an item of plant that needs to be designed before it can be fabricated and brought into existence are far more intimately connected to the item of plant than the costs of insurance that an installer insists on having in order to do the job.
I see that. I mean, I see the way you put the case, and that seems to me to be the focus of proper inquiry, really. What I fail to see, I'm afraid, is any great similarity between those costs and costs of preliminaries. I mean, if you ask what is the cost of constructing a building, it includes the preliminaries, and everyone knows that.
Well, but it also includes, and the revenue accept this in their manual, that it includes the cost of designing the building.
All right.
And then you get, so it's not a question of whether it's distinguishable, it's actually a question of that if the recognised features of the law extend this far, then they ought to extend to cover the expenditure in this case. That's the basic gist of the point.
Okay. Yep.
The fourth point is that the legislation doesn't contain any duality limitation. And by that, I mean that there is no requirement that the expenditure has to be incurred wholly and exclusively on the provision of the plant or machinery. So provided the expenditure was on the provision of plant, it doesn't matter that it might have had some other effect. And the FTT, this is at paragraph 135, and the Court of Appeal at paragraph 75, correctly in my respectful submission, noted that.
So FTT
135.
135.
And Court of Appeal at paragraph 75 noted that. So the relevant statutory question is only whether the expenditure was on the provision of the plant. And then my fifth point is that in answering the statutory question, one has to start from the plant in issue. And this gets me on to the prospective, retrospective debate. In my submission, one starts from the end of the story, as it were. One starts from the plant in issue, and then one looks backwards to identify what was spent on its provision. My learned friend noted the point in section 11, so it's 411 of the bundle, that subsection 4b includes as part of the general rule that the person incurring the expenditure owns the plant or machinery as a result of incurring it. So one is necessarily starting from the point of view that plant has been provided. If not, then the section simply can't apply. And from that position, one can look back to see what expenditure was incurred on its provision. And this is the approach that both the FTT, this is paragraph 134 of the FTT's decision, and the Court of Appeal, paragraph 76, took. And in my submission, not only is that approach correct, but it's difficult to see what other method could realistically be adopted given the nature and terms of the section. And indeed, my learned friend in her submissions in relation to Benedetto, I think said that the approach ought to be that you draw a line around the plant and then you ask what were the acts of providing it, which is essentially the way that the Court of Appeal looked at this. Now, the main difficulty, I suppose, if one puts it that way, that my learned friend identified with the approach the Court of Appeal took was to say, well, an advisor ought to be able to advise the taxpayer at the point at which any given item of expenditure is incurred as to whether that expenditure will qualify. Well, as to that, the difficulty that would face an advisor in that position is no different to any other situation where one was dealing with a prospective or an intended transaction. One takes a view on the law as it stands, to the facts that are supplied, asking the relevant questions, and one can answer that. Yes, there's uncertainty, but in fact the question doesn't properly arise until the point at which the plant is in fact owned. And really, an approach which involves pausing at the point at which some expenditure is incurred and then asking, is it qualifying, does not, with respect, make much sense, because we know that the expenditure can't qualify unless and until plant has been provided. That's clear from the statutory requirements. And the language of 4b implies or expects that the expenditure will come before the plant, because the expenditure or the plant has to be the result of incurring the expenditure. So stopping at the point at which some expenditure has been incurred, but before any plant is acquired, and asking, is it qualifying, is not, with respect to useful exercise. And on a related point, it is, in my respectful submission, nothing to the point that at the moment at which a particular item of expenditure is incurred, plant might not in the end be provided. That is going to be true in almost any given case. To take Barclay Curl again, when one's looking at the excavation expenditure, there was no dry dock. The excavation was a preliminary to the dry dock being constructed. It was possible that that project could have gone no further at that point and the dry dock might never have come into existence. Suppose that Barclay Curl had hit some financial difficulty and it meant they couldn't proceed further.
As HMRC say, there are commercial risks, but the question is, can you advise the taxpayer, assuming everything goes according to plan, will this or will this not be deductible? Things may not go according to plan, but we're not talking about that contingent risk.
Well, the point I was actually making, my lady, was that it is irrelevant to the statutory question, or answering the statutory question, that at the snapshot point in time at which the particular expenditure is incurred, there might in the end not have been plant, is irrelevant to the exercise. The claim can only be made if plant eventuated. So we are always starting from the point at which there is plant. There can be no claim unless there has been plant provided. So looking back and saying, well, if you take the snapshot at that point, leaving aside what's happened after that, perhaps no plant would have come into existence at that stage, is an irrelevance.
I think I understood the submission to be that at the time the taxpayer incurs the liability for which it's going to claim capital allowance, it must have identified the plant or machinery which it is going to acquire, so that it can say to its advisor, if I incur this expenditure with a view to acquiring this piece of plant, will it be deducted? Will I be entitled to capital allowances?
Yes. And then one gets the question, what does it mean to be identifiable? Now, important point here is that when these companies set out and make the bid for the polygon that they're going to get, they know what they are planning to do with that area of the seabed. It wasn't a question of should it be a wind farm or should it be something else. It was only going to be a wind farm. They've done it enough to know what a wind farm would look like, what it takes to build a wind farm. These design points that we're talking about are, if you like, tweaks to that design to make sure that this item of plant is specifically and properly designed for this area of the seabed into which it's going to be installed. So there isn't really a grey area about what the item of plant is going to be. Now, they couldn't say from the very outset exactly what the specifications of that item of plant are going to be because they have to be designed. And it can't be the case that one has to have in mind exactly what the item of plant is going to be, because it would rule out instances where, for example, in Barclay Curl, they hit a snag and they have to tweak the design of the dry dock partway through construction in order to meet a particular problem. It can't be the case that it ceases to qualify because you've had to make a tweak during the point of construction in order to address a particular problem. If one looks at the...
So when they incur this expenditure, they're able to say, if all goes well, we will be installing a wind farm, and that is a sufficient identification of the plant in issue.
If that's what's required, and I think at one point the upper tribunal said that one needs to have in mind a good idea or something along those lines would be installed. Well, they had more than a good idea. If one looks at the findings about the surveys and the studies, they are about what will happen if you install a wind farm of this kind in this area. So it's clear that what was anticipated was that it would be a wind farm. That
Yes, yes. I mean, that must be obvious, really.
But one doesn't even have to get into that kind of approach if one adopts what the Court of Appeal has done, which is that you look at the plant that has been provided and you look at what took to provide it. That doesn't involve any kind of exercise.
In a case where, at the time a particular survey was done, you didn't know what you were going to do with that particular area of seabed, you might have a wind farm, you might do something completely different, it would count, it would qualify, provided you could see that it led to
Yes.
the acquisition of a wind farm.
Yes, but that turns on exactly what role the expenditure had in the provision of the
Yes.
plant that was provided, which is a perfectly valid, plausible, sensible exercise. Now, those are not our facts here because they knew what they were going to build.
Yeah.
There were some exercises which were disallowed by even by the FTT, and that wasn't acknowledged. So it's not that you got everything that you asked for. There was some desktop
Yes.
scoping. So
Yeah.
what is the dividing line then between those and the ones that you are still arguing should be?
So I think the expenditure that was not appealed was the initial desktop assessment and the desktop metocean studies. And the reason why they were not appealed is that the FTT found that those studies did not have a relationship to the design or the installation or construction of the wind farm. But the other studies were found to have a direct relationship to the design or installation of the wind farm.
Right, but wouldn't those also, presumably by the time they did those desktop studies, they knew it was going to be a wind farm rather than anything else? And looking back, you can see that those did contribute to or were part of the ongoing process.
Well, on the FTT's findings, they were not part of the design process. That's the divide.
It's not a question of whether they're part of the design process, it's whether their expenditure incurred on the provision of the wind farm, isn't it?
That's absolutely right.
So
But
why would you say it wasn't, or why? Well, you didn't. Why did the FTT said what? It wasn't related to design or installation.
effectively, yes.
Might, I see.
And the point, the way this case has been argued by the companies at every level, is that in relation to category of expenditure, or relation to a bespoke item of plant, which has to be designed before it can be fabricated in order to come into existence, that is expenditure, to adopt the words of Lord Reid in Berkeley Curl, without which this item of plant could not even be made. So in terms of design costs, they are, as I've submitted, intimately related to the item of plant, because without them, the item of plant cannot come into existence. And one might say that they're more intimately connected with the item of plant than transportation or installation.
And you say the distinction between design process and design. What do you say about that? Which is a line that HMRC been putting.
Well, the line that HMRC draws seems to change depending on what questions are asked. As I'd understood the line that they were drawing, they were willing to draw a line which included within it expenditure on the final design, which they say is the design made real by fabrication. But then they would exclude everything that goes before that. At times in my learned friend submissions, that line seemed to shift a bit to be at the point of fabrication. So there's a change in the case that the revenue are running in that regard. If one looks at the design, and by that I mean, if you like, the final design, that design doesn't come from nowhere. That design doesn't spring into the air. That design is the product of a process which is iterative and cumulative, which results in that drawing. But before that, there might have been the penultimate drawing, which needed tweaking, and so on. There is no principled reason for drawing the line there so that you exclude every other part of the process that's gone before that in that final design. All of that was expenditure without which the item of plant could not even have been made. And if one draws a line at fabrication, well, again, that's not a principled place to draw the line, because the thing that's fabricated has to be fabricated according to a design. So why include only the physical, albeit skilled, aspect of building the thing, but not the intellectual aspect of designing the thing? Both of them contribute to the provision of the plant. The thing can't be built without being designed. So the design is as essential to that final item of plant as the steel from which it's made.
I thought you didn't put forward a test of necessity.
I don't. And this is a key, and perhaps this was an error that with respect to
you said that it was all expenditure without which the plant could not have been made.
Yes.
So it's necessary expenditure.
Well, one could classify that as necessary in that sense.
Well, it's but-for expenditure, but with quite an expanded but-for test. Looking at it now, the plant, what are all the ingredients but for which this plant would not have been made?
The key in my submission is to understand what Lord Reid was saying in Berkeley Curl. Perhaps he could go to that.
Yeah, he says expenditure which must be incurred before the plant can be provided. I think that's the sentence you're referring to, page 526.
At 526, it's D to E.
Yes.
Now, it's important in my submission to understand the context within which Lord Reid made those comments in his speech. So the Special Commissioner's decision had been that this expenditure didn't qualify. If one looks at the bottom of page 524, the very final line, as regards the expenditure of 186,000 odd, the excavation of number 3 dry dock, we found that this was not expenditure on the provision of machinery or plant. In our view, this expenditure was too remote from the provision of the dry dock. It was expenditure on the preparation of land to receive machinery or plant, and as such, attracted allowances only under Chapter 1 of Part 10. And then when Lord Reid, in his speech at page 526, at letter D, addresses this point, in my submission, he's addressing the point with an eye to what the Special Commissioners said. And he's saying, so the question is whether, if the dry dock is plant, the cost of making room for it is expenditure on the provision of the plant for the purposes of the trade of the dock owner. In my view, this can include more than the cost of the plant itself, because plant cannot be said to have been provided for the purposes of the trade until it is installed. Until then, it is of no use for the purposes of the trade. So just pausing there, Lord Reid clearly does not consider the cost of the excavation as being the cost of the plant, because otherwise there's no reason for his lordship to have made the observation that expenditure on the provision of the plant can include more than the cost of the plant itself. And he then continues, this plant, the dock, could not even be made until the necessary excavating had been done. So he's saying, well, you can have installation expenditure because it's not been provided for the purposes of the trade until it's installed. Till then, it's of no use. Here, the plant couldn't even be made until the necessary excavating had been done. And then
you could not provide the dry dock without excavation. And necessarily, the dry dock sits in the excavated space.
Quite.
You couldn't have it somewhere on the side waiting to be installed.
Absolutely, my lord. And the point that Lord Reid is making, if I may just continue with what he said, all the commissioners say in refuting this part of the claim is that the expenditure was too remote from the provision of the dry dock. There, I think they misdirected themselves. if the cost of the provision of plant can include more than the cost of the plant itself, I do not see how expenditure which must be incurred before the plant can be provided can be too remote. So he isn't saying the test is a necessity test, and that's the rule of thumb one is applying. He's saying, in this instance, you couldn't even make the plant unless you did the excavating, so it can't be too remote. It can't be non-qualifying. So the test isn't that anything, it has to be necessary to qualify, but where you have an item of expenditure, in this instance, without which the plant couldn't even be made, then that is qualifying. It can't be too remote. And it's by extension of that reasoning that I've submitted and continue to submit that design costs, the costs of designing a bespoke item of plant are qualifying because they are costs without which that item cannot even be made. I appreciate that building a dry dock is not...
I mean, just generally, because I'm still struggling, as I think my Lord Richards is, with how this fits with your complete rejection of a necessity test. But you're saying it's necessary to design, just generally, it's necessary to design something before building it, and therefore any expense incurred in the design is qualifying. Even if you wouldn't say that particular bit of work is necessary, because design generally is necessary.
Yes.
Then all the expenditure in design is qualifying.
Yes.
Whether it was actually necessary, that bit was necessary or not. Is that how you put it?
Yes. Now, but two points, if I may, in relation to that. First of all, there are some instances where the FTT found that the surveys were necessary. There is a finding to the effect that the surveys in relation to geotechnical and geophysical and the metocean were absolute prerequisites to the design and construction of this item of plant. Without them, you couldn't make this.
Sorry, which surveys were those again?
Metocean.
Metocean.
And the geophysical and geotechnical.
Those are the ones outside the EIA.
They're outside the EIA. But the second point, just coming back to the point that I made about the statutory language, there is no inquiry into whether the expenditure was necessarily incurred. The inquiry involves looking at the plant and looking at what it took to effect its provision. So one doesn't go through the costs and say, well, I know this affected the provision, but we'll carve out these bits because, strictly speaking, you didn't need to do that. There is no such limitation.
Right. Because so you agree that your case is you can't have plant without designing it, unless, I mean, we're talking about bespoke here.
Quite. I mean, it's a factual assessment in each case, because one has to look at...
But even if we are talking about off the shelf, you can't decide what to buy without knowing what you need, and that's sort of designing what you need, so that... Because some of the components were bought off the shelf here, weren't they? But,
yes,
but the information, the studies which provide you with the information to know what you're going to buy...
Well, there's an important distinction, if I may, which is that there's off the shelf and then there are components that are ready made. So if one goes to buy a printer, for example, one can buy that off the shelf. The components that are ready made in this instance, things like the turbine units that sit on the top of the poles, they come in a limited range of models from Siemens. And the choice of which of those to use on the turbines is informed by the information that's gathered as part of the surveys. But that is a component part of the unit of plant. So it would be like deciding whether you needed this particular semiconductor or this particular semiconductor to build into your particular item. It is still a design choice in relation to that item of plant.
The item of plant being the whole wind farm.
It's the whole of the generation assets, but yes, it's that complex unit. So it's not a case that you have to design and build everything from scratch. There are some components that are ready made, but that would be the case in almost every construction project. Now, as set out in the written case, this is paragraphs 48 to 63. I'll come back to this in more detail if I'm able to. The decision of the High Court in McVeigh is, in my submission, supportive of the proposition that the costs of gathering materials and information that are required to determine the physical characteristics of the plant in question, where that plant is bespoke, are part of the expenditure on its provision. My Lord Burrows had asked whether there's any case on design out there. There is a surprising dearth of authority, but in my submission, McVeigh is a case which touches on that. Except it's not a case about designing a wind farm or anything like that, but it is a case which in my submission is instructive in an area of the law where there is not a great deal of authority. And again, as my Lord Burrows observed, one could carry out this exercise in terms of arriving at the right answer by looking at the core of what is accepted as qualifying and then seeing where from that one can develop the law and look at its scope. In circumstances where we have certain parameters already sketched out in this area of the law, in my submission it's relevant to look at those to see how it might be developed, and McVeigh is one of those. In addition to design costs, the companies also incurred expenditure in relation to the installation of the wind farm, and this related to studies that informed the companies as to the safe and effective installation of the plant. And it ranged from advice as to how to minimise the negative impact of installation on marine life to advice as to the location of unexploded ordnance to avoid driving a monopile foundation through a bomb that was lying undetected.
So what, okay, you have, that survey discloses that there are unexploded bombs in 3 locations. What follows from that?
Well, I think you have to redesign the configuration.
But what does that mean?
Well, going back to the reason why I wanted to show the court that plan view of west of Duddon Sands is that when one has to understand the item of plant as that complex array.
Yeah. If one, putting it colloquially, does it mean putting the turbines in different places?
Yes.
Yeah. Okay.
But doing that means redesigning a physical parameter of the plant. It would be like designing a building and having to move a wall. That is a change to the physical characteristics of the thing you are building.
Well, I suppose it may not be a change because you may not yet have determined precisely where you're going to put your turbines.
Well, perhaps, but it depends on...
Gather this information together.
Yes, it's still relevant to your design choices about exactly how the configuration will look within that space.
So it's relevant to the location of individual turbines, but you say, well, that's part of the single item of plant, which are the generation, whatever they are, assets. So well, it's a change in design of that plant.
A change in that shape of that configuration is a change in the physical parameters of the plant.
But you would say that suppose that you had a design and you did you looked for unexploded ordnance and the result came back, and well, fortunately, yes, there is a big bomb there, but fortunately, on the design as currently configured, you wouldn't disturb it, so no need to change. But you would still say that the cost of that survey is qualifying.
Yes. I think my Lord, I think Lord Justice Newey observed in the course of argument in the Court of Appeal that it would be a rather odd situation if your survey qualified if you found a bomb, but not if you didn't. Yes.
But was that a proposition that was accepted by the FTT as well?
I don't know that was a proposition ever advanced by HMRC, although there are a couple
Well, it would be advanced by you if it was advanced by anybody.
Oh, I'm sorry, I misunderstood the proposition.
Well, that you're entitled to this qualifying expenditure for the surveys if the surveys could have but in fact, because of what they say didn't affect
Yes.
or change the design.
Yes, that's always been the company's case. There are a couple of instances where the FTT decided that it would not allow a particular item of expenditure because the result of the survey did not, in fact, result in a change to the wind farm. The ornithological surveys is an example. So the judge noted that in other wind farms, not in issue in this appeal, there had been changes made to the heights of the turbines to take into account the flight heights of the birds, but that hadn't happened in the wind farms in this appeal. And of course, the point of the survey is to find out whether you need to make the change. You don't know before you incur the expenditure on the survey whether there will be a change, and finding out that you don't need a change is just as useful as finding out that you do. Now, the Court of Appeal corrected those errors in the instances where the FTT made them, when it went through the expenditure category by category, and I respectfully endorse all of those.
And you say it still goes to design, even if the environmental impact assessment, and these surveys go into that, is primarily being used to decide whether there should be any wind farm?
Well, first of all, my lord, I don't know that it is primarily being used for that purpose. I think what the revenue would say is that you have, if you like, a dual purpose, which is that part of it is to get the consent, but part of it also suggests mitigation measures and impacts on the environment and so on that you might design out or alter your construction method to take account of.
Right, but say the answer is nothing you can do can actually satisfactorily deal with the detriment to the environment, so you can't go ahead at all.
Well, I don't know that is. I don't know if that's.
You think that's outside the scope of the.
Well, I don't know if that's
assessment.
a possible conclusion. The way that they look at it is to see there are instances where they say there might be this impact, but no mitigation is needed, or it's not possible to mitigate. But you don't know that until you get the results of the survey. If I may just come back to that's the reason I made the point about there's no duality qualification. So the fact that you might say that you carry out the environmental impact assessment because you need to do that to get the consents does not preclude it from being expenditure on the provision of the plant. And the related point to that is the point that I made at the outset of my submissions. This environmental impact assessment doesn't exist for its own sake. It exists so that the wind farm that is to be designed and built is the best fit for the environment into which it's going to be constructed, so that you can take steps to design out impacts on the environment. When you look at the nature of the surveys and what's suggested in them, they are about making sure that the physical characteristics of the item of plant and the process by which it's constructed are doing the least impact in the environment.
But you would say that those that affect the process by which it's constructed are still part of the provision, are still on the provision of the plant. I don't think you're drawing a distinction there between what's qualifying and what's not qualifying.
Well, insofar as the surveys go to the construction aspect, they are part of the installation of the wind farm, because understanding how and when to install is part of the installation process. Again, you're back to attempts by the revenue to disassociate the physical, albeit skilled, process of installing the turbine into the ground and the intellectual process of understanding how best to do that, when in reality those two aspects are intertwined as the process of installation. And in fact, they're iterative. You hit a problem while you're trying to install the thing or integrate it into the ground. There's a question of how and when you might do this. There isn't a principled basis on which to try and extract that from the installation process and say it isn't part of it.
I suppose partly what I'm thinking of is we've always got to think about the possible impact across into other situations far removed from wind farms. So you might say, how does this relate to planning permission, for example? I mean, are we opening the door here to planning permission costs on major infrastructure projects now all being part of the scope of capital allowances?
So, as regards that, 2 points strike me immediately. First of all, Lord Reed is very careful, I respectfully submit, in Berkeley Curl, not to try and spell out a test that you can apply to every single situation to decide whether something is qualifying. Lord Reed looks at the particular costs in issue and he decides which side of the line they are on.
Yeah, but here we are trying to apply what Lord Reed says all these years on. So, you know, in a sense, one's got to have those sort of bigger pictures in mind, surely.
I don't disagree with that, my lord, but the question for the court is whether these categories of expenditure qualify or not. And
yeah.
My respectful submission, Lord Reed very wisely didn't try. In fact, I don't think any judge has tried to lay down a hard and fast rule that you can apply in every single case to decide when something's qualified. This is an area of the law where it's built case by case.
I mean, I think the process here does include something rather like planning permission, because I now think I know what a TWA order is. It's an order under the Transport and Works Act 1992, and it's required, I think, because a wind farm will interfere with rights of navigation in the territorial waters. So that's why you apply for a TWA. As I understand it, please correct me, someone in due course if I'm wrong. And so in that sense, it's a bit analogous to planning permission, because unless presumably you get your TWA order, you won't be allowed to build any wind farm. And there are attached to that requirements for an environmental impact assessment. So the environmental impact assessment, as I understand it very briefly, is part of the process required for getting a TWA.
I think that's correct, my lord, but as I've endeavoured to submit, that impact assessment does not exist for its own sake.
Well, in part it does, because it's there to get the TWA, but you're saying it includes mitigation of environmental impact.
The findings are that the information that is gleaned as part of the process of putting that thing together or feeds into the design of the
But the main purpose, I know this isn't a purpose test, but the main purpose of the EIA is in order to obtain the TWA order, isn't it?
Well, I don't know that there's a finding to that effect.
All right, well,
but also,
maybe.
on the legislation, there's no purpose test and there's no exclusively rule.
So did you pick out certain parts of the costs of the EIA and ask for an allowance for those, or do you seek capital allowances for all the costs of the EIA?
I don't believe it's all of them. The studies are separately identified.
I see.
And to my Lady Rose's question, it's not an all or nothing. But
I think the transport and tourism one is part of the what you're claiming.
Well, that is right, but you have to then delve into the detail of exactly what's covered by that particular survey and that study according to the FTT's findings. If I may just come back to my Lord Burroughs' point about planning permission.
Yeah.
2 further points. Planning permission might determine whether the provision is lawful. But we're talking here about the costs of designing the thing so it can be built. It's not about whether the provision is lawful.
But I thought you said things that are safety related are covered. Isn't that what's lawfully needed for safety?
Well, I dare say that the companies would like to carry out the installation safely and effectively as a commercial matter anyway. But that's a slightly separate question, which is what's the scope of installation here. Just 2 further points on planning, if I may, or they're interlinked. My understanding is that in relation to the construction of buildings, there's a specific exclusion for costs in relation to planning permission. I don't have the section off the top of my head, but I'll provide that to you tomorrow morning, if I may. And in terms of authority on the scope of whether planning permission or the cost of planning permission would qualify, I'm not aware that there is a great deal. I think in the Wimpy and Warland case, which is a case that we have in the bundle, the special commissioners had decided as a matter of principle that the costs of that planning fees would qualify. I don't understand that was challenged on appeal. Perhaps again I can give you the references to that tomorrow morning.
Thank you. That might be a convenient point. Thank you, Mr. Jones. There's one matter I should have raised with you and with Ms. Wilson. I see there's a stenographer in court. I don't know if it's the intention to produce a transcript, and if so, if it's the intention, it should be supplied to the court.
I'm sure it is the intention to supply it.
Well, we're very grateful, and we'll gratefully receive that in due course. Thank you very much. So we'll resume tomorrow morning, please, at 10 o'clock, when you'll have 2 hours, Mr. Jones?
10:30.
I'm sorry, 10:30, thank you. 10:30, when you'll have 2 hours, and then we'll have half an hour to reply. Thank you very much. The court is now adjourned.